Good morning, everybody. I think we can start this training while the last people join the meeting. I'm really glad to welcome you on behalf of GILL project. I'm Gabriella Quaranta, and I'm working in the European Network of Living Labs, coordinating the project together with my colleague Arianna Marucci. And I'm here to just briefly introduce you to the training that we are going to have today and to share a few insights about the GILL project which is hosting this second training in its 2025 capacity building program. So the training of today will be about intellectual property in collaborative environments. And before going into the training, I would like just to remind the housekeeping rules. So as you already know through the registration forms and information received previously, this session will be recorded. We kindly ask you to keep your mic muted when you're not talking, so to avoid background noise. If you have any questions, please feel free to write them in the chat whenever you want, no problems. And remind that this is a safe space, so any question or contributions might be relevant for anybody, and all interventions are equally valid. Why this training? So the learning objectives of today's trainings are understanding intellectual property in innovation and living labs. So to be able to have a comprehensive understanding of what constitutes a living lab and the critical role of intellectual property while fostering innovation in collaborative environments. Familiarizing with general intellectual property principles and applications, so to be able to acquire knowledge about the different types of intellectual property rights and precisely learning how these rights can be applied in collaborative settings, such as, for example, living labs. Implementing effective IP management practices, learning best practices for managing and sharing intellectual property rights in living labs, including establishing fair agreements and balancing openness with protection to foster successful innovation. And last but not least, recognizing and addressing intellectual property issues throughout project development. So through the identification of all the key steps within the project development where intellectual property issues should be considered, and trying to understand how to navigate IP challenges during team formation and collaboration with external stakeholders. Today's agenda is quite packed, but very interesting. We are going to have a short introduction, then a brief presentation about living labs and their role in the innovation, importance of intellectual property in the innovation process, an overview of intellectual property rights. Then we're going to dive into sharing rights, understanding how to balance openness and protection in collaborative environments, and addressing IP strategy in project management. The last part of the training will be devoted to the presentation of real-life examples on successful intellectual property management in co-creation. Then we are closing with lessons learned and ethical considerations. As you may see from the agenda, we're going to have a question and answers session at the end. But again, if you need to write any questions during the training, please do not hesitate to put it in the chat. Your trainers of today will be Giulia Campodonico, one of my colleagues in Enol. She's the head of projects and she has over 15 years of work experience in European policies and projects in the research and innovation field. She joined Enol in 2022. And in her role, Giulia focuses on coordinating the association work on proposal preparation and project management, while also supporting the European Network of Living Labs services to its members. She also brilliantly coordinates the Soil Framework Partnership and the Soil Startup Project. Before joining Enol, Giulia led many different European proposals and projects, working in the proposals and projects team at the Italian Institute of Technology, which is one of the biggest research institutes in Italy. Her background is in political sciences, journalism, European studies, and project management. Giulia has really a great experience in project management for mid-high TRL technology and innovation, with particular attention on ensuring each tech transfer results valorization and exploitation, and of course, intellectual property management. Together with Rasul Abibipour, the trainer for the second trainer for this training, who is an associate professor in information systems at Lulea University of Technology, and he is also the managing director of Botnia Living Lab, which is one of our members. Rasul also holds a research fellowship at the School for Data Science and Computational Thinking at the Stellenbosch University in South Africa, and his research focuses on participatory design and user engagement information system development processes, with a very strong focus and emphasis on living labs. He has been involved in teaching and supervising students at the bachelor, master, and PhD levels, and he has published a lot of journal and conference articles on his research topic. Rasul has been involved in several international innovation and research projects as project coordinator and project leader, most of which focused on digital transformation and living labs, participatory design, as well as research on higher education. So I would like again, on behalf of GILL and on behalf of all the participants, to warmly thank Julia and Rasul for being here today as trainers. Going to the GILL project, who is organizing and hosting this training, I would like to briefly present the project. GILL, the Gendered Innovation Living Labs, started 2 years ago. We are in the last year of the project, and it was funded under the WIDERA program of Horizon Europe. GILL aims at creating a pan-European living lab and tools that aims at supporting gender-responsive smart innovation and entrepreneurship, with three main goals in mind: making open innovation ecosystem inclusive, aligning innovation with society's needs, expectation, and values, and broadening knowledge and collaboration among citizens, government, industry, and academia. So involving the whole quadruple helix in our work under the project. We are focusing on four main priorities, of course, linking to what has been presented in the previous slides. So enabling organizational and cultural changes, increased integration of gender and diversity aspects into product design, technology, and innovation, enhance professional development, and allow gendered educational practices. GILL focus on three vertical priorities or domains, which are the health and resilience, green transition, digital transformation, and works also on horizontal innovation spheres, tools and methods, innovation and products, individual and team, societal and processes. And all these domains, horizontal and vertical, are integrated into the 15 action-oriented experimentations that are included in the project, which are many different and might very different and might integrate more of the domains that are presented in the previous slides, and that are aiming at assessing how innovation is supporting in their center, how the generation of ideas flows, enhancing the scope of women's input into this. The 15 action-oriented experimentation are actually working as living labs. So they are treated as pilot living labs, trying to following the iterative cycle and understanding their problems, evaluating the problems, co-creating solutions. So to really develop new approaches to gendered innovations, test and changes. Of course, always enhancing the gender responsive smart innovation and entrepreneurship. We have been launching also our online platform in October last year, which is a hub that actually encloses many interesting tools that might support you while addressing gender and diversity issues in your daily work, research, project, innovation, or entrepreneurship domain. We are, of course, collecting good practices. There are a lot of gender responsive methods that can really support you about changing your everyday practices to be more gender responsive. So please check it out. We also are developing a toolbox in which you can find a lot of different tools that can be useful while supporting gender responsive smart innovation and entrepreneurship. We have training material, and of course also the training of today and the previous one about stakeholder engagement and co-creation will be available on this platform. We have the part related to glossary, where very important definitions related to gender and innovation are explained. We have role models, mentoring, and this is a section that will be launched in the next few days. Will allow you to book bilateral meetings with experts that can really support you, providing guidance and insights, of course, with reference to the integration of the gender dimension in innovation and entrepreneurship. And of course, we also have the network and the forum section. So the hub really offers many different tools that might be relevant for any of you working in the research and innovation, focusing on gender and diversity issues, and of course, drawing your path in innovation and entrepreneurship as well. I'll leave you the link here so you can access to any of these resources whenever you want. Now, before going to the different sections of the training, I kindly ask you to join this Mentimeter. It will be really fast, but it will provide a first overview of the participants that are joining the training today. And to do so, just use the QR code, or you can go to menti.com, and through the code 36199386, you can access, of course, the survey. I will also put the code into the chat so it will be faster for you to reach it out.
Good morning, everyone. I would like to give you a few more minutes just to start to get into the Mentimeter, and then I will move to Mentimeter to see what we're doing. By the way, this section is to be considered as a warm-up for the training to come. So it will be very short and just a very few questions to see how you feel about the topic that we're going to touch upon today, and to see what are your expectations for today. So I guess some of you have already started to get in. I will stop sharing this part and go to Mentimeter. Oh, I see you already started typing in your answers. So the first question was, what are your expectations for today? And of course, many of the answers are about learning and get new knowledge about IP, IPR issues, get insights and examples, and you will get them. So you are in the right place if you're looking for them. Get acquainted with GILL. That's great. We also left some the links that you can go to in the chat so you can learn more about the project and the hub. So thank you for your interest. Okay, new possibilities, insights, exchange, which is also always something that is very, very important in this field. Case studies. Okay, so it's great that we're all very keen to learn new things today, which is hopefully what you will leave this training with, new knowledge on these topics. So I think many of you have voted. We can move on to the next question for this Mentimeter, which is, on a 1 to 5 scale, how would you define your knowledge or expertise in living labs and intellectual property and technology transfer? Okay, the first votes are starting to come in. This is also important for us to see whether after this training you will feel more comfortable and more acknowledged on these topics, and whether you will feel more confident in putting them into practice in your future work. So this is a very important data for us to register, let's say. Okay, so I think we're quite stable with 3 out of 5 for Living Labs and 2 out of 5 for intellectual property and technology transfer. I think we can move on to the next and last Mentimeter for now. So, what short phrases come to your mind when you think of IP in collaborative environments? And for this, please just type not the first things that come to your mind in general, but don't overthink it and tell us the first things that come to your mind really when you think of this topic. Problems. Okay, we have to conflict, conflict in ownership and conflict, yes. Again, difficulties, but also uh, cooperation and agreement, tension between sharing and protecting ideas. Hopefully, all the issues that you've encountered will be in a way clarified with today's training. We're gonna more or less going to touch upon all of the topics that you're mentioning. So this is great actually. Here of not acknowledging everyone. And also, yes, we have a lot of there are a lot of thoughts about conflicts in sharing knowledge with others or other partners. Okay, I think we are ready after this icebreaker to move on to the actual training. Thank you so much for taking part to this Mentimeter. As I said before, it is actually very important to have these thoughts before, and let's see what your mood is going to be at the end of the training. So going back to the main presentation.
Great. Thanks a lot,
Okay.
Tatiana, for the Menti. So I would now give the floor to Julia and Rasul, our trainings, to go into the different sessions foreseen for today. Thank you.
Thank you very much and welcome everyone. Really glad to be here. We see the entire training is dedicated to IP in collaborative environments. But what do we mean by collaborative environments? These could be spaces, physical, digital, where multiple individuals, organizations come together to share knowledge, resources, and experience, working together for skill development, education, open innovation, co-creation, and they are really designed to foster interaction, collaboration, and collective problem solving. We can see different types of collaborative environments, for example, social learning networks, online learning platforms, workplace learning communities, co-working space, and most importantly, living labs that are the focus also of our examples and trainings today. But what are living labs? And all the European network of living labs is defining living labs as open innovation ecosystems in real life environment based on a systematic user co-creation approach that integrates research and innovation activities in communities and placing the citizens or the users at the center of innovation. Based on this, we see that the living labs operate as intermediary among the quadruple helix and the key actors across the quadruple helix that you see depicted here in the slides, representing the academia environment, the public sector, the government, the private sector with industries and companies, but also the citizens, the users. And all of these needs to work together through the Living Lab orchestration for joint value co-creation in real life and using iterative feedback processes. But delving more into the definition, so we can see the open innovation. Open innovation means that everyone needs to have access to the innovation on one side, but also access to the possibility of contributing to the innovation in a continuous process, being really at the center from every angle, and therefore contributing to user-driven innovation. But living labs also particularly operate in real life environment. It could be a field, it could be a city, a quarter, or other hospital, or other, depending on the thematics and the focus. And for this, it's also important to remind that it's not sufficient to have the specific real life environment. We also need the people. And by people, we mean, for example, in the urban living lab example, we need a public administration that is the maybe the driver of the innovation, to working together with key actors such as urban planners, but focusing on developing or improving the existing infrastructure and technology. And often in collaboration with academics and researchers that can contribute to the project. But this is not sufficient. For being real living lab, we need to consider all the key actors that may have a stake or be affected by the transformation, for example, of a quarter. In that case, could be affecting the existing or future commerce and retailers, as well as the real estate professionals, maybe that can see a change in the price range of the quarter we are working on. But let's not forget the key actors that are affected, which means all the citizens that are have a stake and should have a say in the decisions of a urban living lab, for example. Looking more, the living labs are called for doing transformation, and this transformation needs to be valid all for one, meaning that all the actors need to act for one common goal, but this common goal needs to be valid for all of them, for all the actors involved in the transformation. And only by doing this systematically, we can transform the living labs into trustful regional ecosystems, building trust. Trust is essential for living labs. It takes time, but it's the essential element of living labs to really confirm that the living lab is a safe environment, to really be able for all actors to contribute, but also bringing value and receiving value, making sure that the inputs that is provided is not wasting time, but is really taken into consideration and used for the sake of the living labs. And through this, we can then, with the regular implementation and building of trust, we can transform and build living labs as a tool for research, and really consider the living labs as a service of the science, as real research infrastructure in real life environment, or technology research infrastructure that really contribute through the co-research to the different services and for the sake of the regional environment they operate in. But now we have an understanding of what are living labs, but why living labs? There are multiple reasons that are already hindered behind the definition we just saw before. And in this case, we saw the real life environment, that living labs address complex societal challenges. But what is important is the involvement of all the actors across the quadruple helix, and in particular of the end users, the citizens, the users in the entire innovation process. So not only in the validation, but in every step of the journey. And this brings multiple benefits. And first of all, it gives an already direct and early adoption insight on the potential adoption of the solution that is researched or developed, and therefore bridging the research market gap. And all this contributes to a faster innovation cycle, because it's a faster iteration and prototyping of solution, and that also supports the de-risking of innovation. So we see multiple benefits of the living labs, but how this operates concretely, because we are talking of innovation, we are talking of multiple stakeholders how this works. And this is exactly what we are going to address today. But before entering into these details, let's have a reminder of what is IP and why IP is so important in the entire innovation process. So starting from the definition, IP, intellectual property, is defined as the creation of the mind. This can include inventions, literary, artistic works, design, symbols, name, images. So it's really broad. It's a definition for every aspect, from ideas to products, inventions, work of art, and literature. What is important is to distinguish the knowledge from the creativity. So IP is innovation. It can be commercially useful or useful to the society, but can be protected. And it does not mean that it's only technology-oriented, technological, but may be created within any organization or any faculty or department or units of the different organization or by the individuals. But why IP is so important? Well, first of all, it's an essential business asset in the entire knowledge economy, and it protects in particular small innovative firms. Probably you're not so familiar with Gore and Associated, but you have all were Gore-Tex products for sure. Or maybe you're not so familiar with the Dolby laboratories, which were pretty small at the beginning, but that survived, and you all benefited most probably of the noise reduction tech of the Dolby tools. But this is not only what IP is doing. So IP has a strong role in the innovation process. First of all, it's the foundation for the innovation. Imagine IP as the building bricks and building blocks, like a Lego, for helping you build new products, new services, and continuing the improvements and the innovation in your ways. Then it also facilitates the knowledge exchange, so that you can really facilitate ideas and the technologies, and build also on the technologies and the existing knowledge of of others, while contributing with your new insights. It also helps resource allocation. So in some cases, resources can be, or focus can be, redirected towards more promising research areas or more promising and IP delivering actions and sections or departments within an organization. At the same time, it incentivizes the creativity. So again, as the building blocks we were seeing before, it really builds and gives chances of new creativity, new creation, new actions, but it also supports collaboration. We were seeing before that sharing the knowledge exchange can be happening within the same organization, but also between the different organizations. But this is possible only when we have a clear ownership and identification of who brings what to the table. And it also enables the commercialization, because it also supports the transformation of ideas into maybe marketable products or services. And this is, again, what we were saying before, bridging the gap between the research and the real life application. And finally, it attracts funding. This is at the base. Many of you may have participated in, for example, in EU projects, and bringing IP is surely a matter to support in securing grants, or also in securing industry sponsorships. It also gives the possibility of licensing, of providing and having monetize your ideas, your creativity, by licensing your solutions to other actors, could be industry partners, but not necessarily only. And also it enhances your reputation, which we know is particularly relevant, especially in the research domain, for building your profile as an organization, as a department, or as a researcher. What do we do with the IP? Why IP is important? Because there are many different solutions, many different use of the IP. First of all, it can be used for further research. So you can build on the existing intellectual property to advance research and explore new innovations. Or you can develop and selling new products built based on these IP. You can even consider to create new companies, startups, spin-offs to bring this IP-based innovation to the market. Or you can consider the creation of cooperation agreements or joint ventures that can continue working on develop and commercialize this IP, maybe opening the collaboration with industry, other academic institutions, or other sectors and actors. You can sell your IP rights. So if you have this IP, you can even consider to transfer the ownership and the IP rights that we will see in a second, or the entire business that you build around this to other actors for continuing the work for you. You can license, so still keeping the ownership, but granting the permission to use the IP in exchange of royalties or other compensation. And this licensing can be done exclusive or non-exclusive based on what you prefer. Or you can use it for further teaching, for improving the academy or training programs, offering specialized courses maybe within academia. Or you can contribute to standards. You can engage, for example, in ongoing standardization process, or contribute to the creation of new standards. A basic example in this sector is for sure the USB-C that we all are so happy to have at the moment, because it reduces the number of cables we need all to carry around, and this is the result of an IP and of standardization activities that have been done after the development of IP. Okay, if there are any questions, we address the questions at the end, right? If I'm not mistaken, so maybe we can continue for this part. Thank you. So we saw what is intellectual property, but what are the intellectual property rights? Again, there is a formal definition which defines IPRs as legal protections that are granted to the creators and inventors for all their inventions, literary, artistic works, symbol names, images, and so on. So all the protection for the intellectual property. And why IPR is so important is because, first of all, it ensures that whoever the inventors, the creator who brought this IP to the world, can decide how to control and how to use what they have invented and created. So this is the first protection. Then it also prevents theft. So it prevents from the unauthorized use, copying, or stealing of your creation. And finally, it gives you the decision on leaves the decision to you on who can use it. You can give this, you can exclude actors that can not use your IP, or you can limit the use to specific actors only. Therefore, you are really securing your own interest and the potential value of your IP by identifying which actors can use or cannot use your IP, and for which purposes. So this is the core of the IPRs. But how many IPR types? So we see there are different types of IPRs that can be used for different types of IP, and that requires different modalities for securing the IPR. Some of these require a formal application, and some of these require only automatic. So the first and probably most common type of IP is the patent. The patent is probably the most expensive, but also the most secure way of securing your intellectual property, and is used only for new inventions or discoveries. There is also utility models. This is, let's say, a simplified patent. So it's still used for new inventions, but the criteria for application and registration are less stringent, and also, but also less secure type of protections. Then there is the registered design. In this case, only there are no application, but only registration process, and this is used mainly for visual designs of products. A simple example that we are all familiar with in the last days is the Oscar. So every time we mention the Oscar, the words Oscar always comes with R to protecting the visual design of the Oscar, the brand, and the statue design, for example. There are also trademarks, which are pretty common to protect symbol names, logos, and to really clearly identify goods and services. And in this case, it's necessary to both apply and register. But then there are also simplified IPR types that are automatic. So they don't require a formal and payment and application and process and examination, but are automatic. One of these is the copyright, the C that we saw many places, many times. And this is used, it's automatic. So just putting the C before your organization automatically grants you the copyright, and is to protect original, creative, or artistic forms. And also, finally, there is, the trade secret, which here is for protecting confidential business information, and is done only within the organization to protect the confidentiality practices within the organization. So it's really to make sure that for example, the process, the solutions, the recipe, or other is not disclosed beyond the organization you work for. But these are the different types of IP. It's also important to remind that the same product can have multiple IPRs. So they're taking two very basic examples: a bottle of Coke and that we probably all drank in our life, or a smartphone that we are all so dependent on these days. All these have multiple IPs. So considering the bottle of Coke, we can see trademarks that have been registered for the logo, the brand name, and even the specific color red that is used for the bottle of Coke. There's also copyrights for the different advertisements and promotional materials that have been protected. There are patents for the production processes, the packaging technologies, the packaging improvement. The design of the specific bottle shape has been protected. And we all know how difficult it is to reproduce a specific recipe, because this is a trade secret together with the manufacturing know-how. So this, you see, only a bottle of Coke contains all these IPRs that have been protected along the way. Similarly, for a smartphone, you can have the trademarks for the brand, for the specific product, for the tone. You know that all the different brands have different startup tones or others, and these are trademarks. But we also have copyrights for the software, user manuals, ringtones, and others. Designs for the shape, the form of the phone, the buttons, and so on. So you see that the same product can contain different IP that can come from the same organization, can come from multiple organizations, or can be created by different actors in collaborative environments. And before opening more into the IP, just a final overview of the IPR protection from the geographical point of view, because not only you need to consider how to protect, so what is your IP, how to better protect it based on your IP and the application process, but also you need to consider the geographical scope of your IP protection. And this can be based at different levels. The first one is at country level. In that case, you protect your IP only in your country. In this case, makes sense when you're operating mainly in one country, or when you have budget constraints that limit broader protection. And in this case, you will need to refer to the specific country patent or trademark offices. And here you have an example of the Polish case. In other cases, you can go broader at regional level, and that is, you can, for example, protect your IP across multiple countries within a specific region. And in that case, can be making sense when your activities and your actions are targeting multiple, for example, European Union countries, or when you seek a broader protection across Europe. In that case, you can refer to the European Patent Office, trademarks, and other European Union organization that can help you in the process and for the application. Or finally, when you're really planning to enter a global scale, you can consider the international protection. Of course, the higher you protect, the higher the cost of your application registration process will be. But this really ensures the protection across multiple countries through different applications. And for these different tools are existing, for example, the Patent Cooperation Treaty to support the patent application, but also there is a Madrid system for international trademark registrations, Hague system for international design registration, and so on and so forth. So this is just a very preliminary overview, but now I would like to give the floor to Razul to continue and really give an overview of how to share rights now that we know what they are.
Okay, thank you, Julia. And hello, everyone. From my side, very welcome to this session. So next slide, please. So as Julia explained and introduced very nicely, the concept of collaborative environment. In a collaborative environment, of course, different stakeholders, including individual users, they share knowledge, ideas, and data with, between themselves and outside of their collaboration boundaries. So that is very important for us to understand how we should maintain a balance between the protection and also the level of openness. So that is very important. Striking the right balance will affect the trust, innovation, adoption, and also long-term sustainability. Why do we say, for example, about innovation adoption? That is something that research has shown very clearly, that if, for example, we are developing a solution or an innovation, then end users, in case that they have seen a more transparent collaboration and communication between different stakeholders in the innovation process, the adoption and diffusion rate will be, of course, higher. And is the same with trust. I mean, now I am trying to connect it that not only within the network, but it will affect what we are developing for end users and the target users. When we speak about trust, also that's the same, because, for example, when we ask users that they want to adopt a technology or innovation, they do not think about trust only from the perspective of the technology or innovation itself, but sometimes they do not really adopt or use the innovations and technology because they do not trust the whole team that they have developed the new technologies or innovation. Just that is something that I wanted to highlight, that it will affect a transparent collaboration in collaborative environment, will impact the innovation throughout their life cycle and also afterwards. So please, next slide. What is important here, and also we realized from some of your input in Menti, is to understand how we should maintain a balance between the level of openness and also protection. That is very important. We have the concept of open innovation, as you heard in the beginning of this presentation from Julia. So the essence is that external sources of knowledge and ideas should be included in the innovation process. But the point is that there is not everything that we can always share. We should really maintain a balance between the two. So am I going to give you a solution, one solution that can be applicable in every setting? No. What we are trying to do today is to make you aware of possible solutions, possible problems, and also see what can be done in, for example, different situation. But there is not really a clear one solution for every project type or application domain. So when we speak about openness, of course, open innovation, as I said, highlights inclusion of external sources of knowledge and idea. That means it is corresponds with the concept of outside in open innovation. And we have also the other way around, which means inside out. the collaborative environment, they should also share the knowledge and ideas to the target audience always. So what is the benefit of sharing knowledge and idea with, with every external or other stakeholders? It will foster creativity and innovativeness. Also, it will enhance collaboration and trust among different stakeholders. But of course, there is always the risk of IT violence, because there are always some partners in a collaborative network that they have some competitive advantage. And it's not the case that when we think about openness and open innovation, everything must be shared with everyone. We should also be protective sometimes to safeguard intellectual property and sensitive information. So that is also the benefit, is that it ensures recognition and security of contribution for every contributors. If they feel that if they are part of the network, but we cannot really protect their competitive advantage, they might not join the network, or maybe they will not see a clear benefit on it. So that is very important. But anyhow, on the other hand, it may hinder open communication, and also it may create barriers for innovation development. Next slide, please. So here is what we can, for example, think about it when I will explain about some real life examples from our previous projects. It will be clearer, but just an overview. What we can do is that to define ownership, licensing, and usage rights early. And that's very in line with one of the key principles of Living Labs. In Living Labs, we usually speak about openness, transparency, but we have one principle highlights early and continuous stakeholder engagement from very beginning. And that's the same here. We should always define ownership and IP protocols and standards from very early. And in many cases, as I will show you, we should do it even before the project. So we should be proactive in this way. And when it comes to intellectual property right, that is the point, that is the key. Should we always be proactive? The answer is most probably yes, maybe not always. That means we should be prepared to be reactive in some specific situation. If we are in the middle of a project or innovation activity, and we see that we really need to do some changes in IP protocols or standards or agreement, but as something general, it's of course recommended to be proactive. We know that what we'll do in the lifetime of this project or this collaborative activity, and also act accordingly, usually before we start doing activities and sharing knowledge and ideas with everyone. So every stakeholder should feel comfortable sharing their ideas. So the trust here is very important. It will foster open dialogue between different stakeholders in this setting. When I will back to the real project examples, I will explain them more in depth with, a situation that we have tried to protect and also be open. But that is an overview of how to balance the act between the level of openness and protection. Next slide, please. So it's Julie.
Yes, thank you. As Razul was saying, there are different steps and actions, but also as we saw before, there are different collaborative collaboration environments, and projects, collaborative projects are usually one of these. So it's also important that we defined our IP strategy in every steps of the project management. And for this project management is really to ensure that you protect your innovation, you ensure compliance, but also you maximize the value. And this can happen in formal projects where this is where you're working together with other partners through grants and a structured grant agreement and requirements that you need to follow. But it's also important that you apply this in every other project, maybe internal projects that you can run in your living lab, or internal projects that you can work in collaboration with other actors, with other stakeholders, with as Rasul was presenting. In both cases, you need to make sure that you protect your IP, that you have a formal agreement, and so on. Take into consideration the formal projects, and in particular the let's say the Horizon Europe example, we need to consider IP along all the different steps of the process, in particular the 4 key stages. So the proposal preparation, when you build your consortium, the evaluation and contract, so preparing the start of your project, the project implementation, but also the project closure. So what happens beyond. The proposal preparation usually takes from 3 to 9 months, sometimes longer, sometimes shorter, depending on how much time we want to dedicate. Here's where the project idea is coming up, where the consortium is created, the work plan is defined, but it's also where the initial IP strategy needs to be agreed with all the partners that are brought on board. Then you have the evaluation contract. So usually this in Horizon takes 8 months. 5 months for the evaluation and 3 months for the grant agreement preparation. And this is also the moment where you need to have your consortium agreement negotiation and agreement and signature. Then you have the project implementation, which can run from 1 to 4 years. We see that Horizon 2020 or previous projects were longer. Here is where you run the activities, where you deliver your IP, where you need to protect your IP, and also where you need to promote and disseminate and start the exploitation and further use of your IP. But also after the project is where you need to fill the final report, including for Horizon Europe, the results ownership list. So meaning defining who owns your IP, where you will have the final review, and where you need to start the post-project IP management. Looking more into the proposal phase, what is important not to forget in this stage is that you need to identify from the very beginning the rules for running your project if successful. So identify who brings which background, which existing IP to the consortium for developing new research. What are the access rules and conditions different actors pose on using this background intellectual property, this existing IP, for working together, and from the working together, which potential IP will come out of your project, who will own it, in theory, then knowing that the specific details can be defined by the project, but also you can consider to have NDAs among the partners to protect discussions, especially if some of the IP you're bringing is particularly sensitive. Then during the evaluation and contract, you will of course work on signing and defining the action plan and the grant agreement. That is the moment where you will need to re-study the grant agreement provision, making sure you know what the funding organization requests you in terms of intellectual property, is where you formally also define the background IP. You had the general definition. Here is where you identification. Here is where you define the background IP in your consortium agreement, where you define also the general IP rules that will run your consortium. From what are the ownership rights? Who has the ownership rights? Individual or joint ownerships? Who has access rights to accessing existing IP or IP that is developed in the project, for which reasons, which conditions, and so on, but also defining the confidentiality rules. So when you can disseminate information, where you need to keep confidentiality among the consortium, and how the different partners can distinguish between what can be disclosed and what needs to be kept confidential. Then you have the project implementation. Here it's, as we say, it's a long process. And here it's important that you document all the innovation, all the IP, and identify all the needs of protection of your IP. And it's particularly important that you protect your IP before, if you can protect it before any public disclosure, any joint publication, individual publication, or even when referring to external experts. Many of the Horizon projects have external advisory boards or support boards or ethical boards or others that are not formally binded by your consortium agreement, but still needs to access your information. Make sure to have non-disclosure agreements, NDAs, to protect your IP and defining how you're sharing this IP, for which scope, and how they can be reused. But also start planning the exploitation. This is a requirement in Horizon, for example, but you need to start planning the further use of your IP, commercialization or eventual market-specific protection, or maybe just further research or further activities. And don't forget, in the project closure, this is still an important part, not funded. So it's free time, but free time that you need to dedicate also to report on all the IP you generated and respond on the fulfillment to the agreements. But also is where you can handle the different ongoing IPRs, identifying the different licensings and commercialization, and continue the eventual IP protection. IP protection, we saw in some cases, it requires application, registration, and can be a lengthy process that can happen also beyond the project. So it's really important that you don't forget this process for ensuring the long-term benefits. For this, now that we see the basis and the different steps, I give the floor back to Rasul to provide concrete real-life examples.
Okay, thank you, Julia. So here we try to share with you some examples that we have, for example, in our previous project, we have faced some challenges and the ways that we tried to manage. For example, how the issues we have faced in relation to level of openness and also protection, how it should be managed. So I have 3 examples for you. And of course, the whole project, these are something that may happen in every project, but just some to give you some ideas what may happen, and specifically in European projects, what is expected from your financiers. Usually they expect you to be very open, but on the other hand, you want to, or some project partners in the collaborative networks, they want to really protect some IPs to keep in the, to keep their competitive advantage. The first project, it's called UNALab, Urban Nature Labs, and that is very closely connected to the concept of Urban Living Lab, as Julia presented. And the intention of this project was to develop nature-based solutions in the European cities with the possibility to replicate the nature-based solutions and upscale them after the project lifetime. So before I go directly to the concept of UNALab project, I can explain that in a living lab, because now, my projects are mostly related to living lab, but in living lab projects, the innovation can be many, many different things. Here, for example, in urban living lab project, when we are developing nature-based solutions in the cities, the innovation here is nature-based solution. In the next project, for example, I will share with you, it's about, for example, sensors and IoT-based technologies for air pollution in connection to the healthcare sector. So innovation can be digital solutions or IoT sensors or even mobile applications. Or, for example, in some of our Living Lab projects, we have developed MOOC courses, open courses with different stakeholders, students, teachers, and also technology platform provider companies. So that means even university courses can be developed following a living lab approach. That's a very short background just to tell you why I am saying nature-based solution as innovation. In this project, the intention was to develop these solutions by engaging every, sorry, yes, by engagement of different stakeholders in the innovation process. And the goal was to replicate these nature-based solution in different European cities. We had three main front-runner cities that we started developing those solutions, like, for example, green roof, green wall, or sensors for measuring air pollution in different city places. And then we had six other cities, we called them like follower cities, that they replicated these technology development. So here is the question: to what extent the nature-based solutions that we have developed should be open and should be available to everyone to replicate, and what should be protected? In this project, the main point was that the technology providers, we have developed dashboard, we have developed IoT sensors, and at that time it was 2017. There were not still like today AI based. I mean, it was not very common to have AI based technologies. I mean, like we have it today, but still the technology partners in the collaborative network, they wanted to protect their ideas and also what they have developed to be used by themselves as well. So we had three main steps in UNALab project. If you can please show the next slide. We had three main activities that you can, of course, think about it. And the good thing with UNALab is that the resources all are available and the website is up and running. There are a lot of toolkits, methods, handbooks, and deliverables publicly available. So it's the three steps that we have done to make it clear how should we open, but also we should protect some IPs for the project partners. The three steps were replication, upscaling, and exploitation. For each of these three concepts, we had a very big task, a separate handbook, a separate toolkit, and also guidelines to do that. So with replication, it was clear that the nature-based solution itself can be replicated by everyone. And in upscaling plan, we had like nature-based solution road mapping toolkit. And in this toolkit, we have clearly explained that these are the ways that in your city you can develop nature-based solutions following Living Lab approach. But from the beginning of the project, we had one activity that every 3 months we had a meeting about exploitable results. And here we could make it very clear. For example, the Living Lab parts that we were working very closely with ENOL, European Network of Living Lab, we were developing like handbooks and toolkits and some gamification approach. We made it, of course, open. So we made it, yes, this is an exploitable results out of UNA Lab project. But those technology providers who have developed the dashboard, they wanted it to be protected. And in the proposal stage, we have mentioned it very clearly that these are exploitable, these are not exploitable. However, European Commission usually expects that we should be as open as possible, but still it's very possible to say that some technological elements must be protected. And I will show you in my next example that even we can file patenting in European projects that say that we are developing something that should be completely protected and it's not openly accessible and available. So as you can see, the project deliverables, for example, about Living Lab roadmap, toolkit, handbook, these are always publicly available. And in the exploitation plan, we have outlined, we have made it very clear what is open, what is not open. And we kept updating these exploitable results every 3 months in the 5 years project lifetime. So, I mean, basically, cities could replicate and upscale nature-based solutions, but companies retained IP over IoT technologies and tools and sensors that they have developed in this project. If you show, please, the next project. The next project, which is still ongoing, it's called Synergy. The focus is on making air quality in a school environment better. And that is also a project in which we have 5 countries as a pilot in Europe with some selected schools. what we do in this project is that we are developing some sensors and also some technologies like big boxes that now we are kind of finalizing this solution to be put in classroom in indoor environment in the classroom to make air quality better. And there is also very specific focus in this project on children who have problems like allergy or asthma or this kind of thing. That means we are collecting sensitive data from our users, healthcare related data, and also we are developing technologies, but still we should have the knowledge and whatever we are producing. I mean, knowledge wise and research wise, we should share it openly with every stakeholder. But our technology partners and innovation developers, they want the technology to be protected. What we did in this project was that from the proposal stage, when we were discussing with our technical developers, and this is also some solutions based on because we are collecting data from AI from IoT sensors, and we have some AI-driven solutions for that. So we proposed to file two patents out of Synergy project. That means from the proposal stage, we propose that these two things must be completely protected. And if you can please show the next slide. I can just explain that this is something that for me, for example, in my previous project, I have never had this experience that from the proposal stage, we can already specify that these are the things that we can file as a patent and we can protect it completely for our, for example, technological or technical partners. And these patents, of course, help the partners to secure competitive advantage within Europe and ensure that commercially viable, valuable innovations remain protected. We, for example, the other thing we have done in this project was to develop a game for children based on gamification approach. We tried to educate them to understand about air quality and air pollution in a school environment, but also we were collecting data from them. I mean, in the game we have some questionnaire and they answer how do they feel and before installing the sensors, after installing the sensors. And that is something that we had a lot of discussions in this project about the ethical aspects of using these health related data. And the potential challenge here is that we should consider how the data can be reused. Because, I mean, I will show you when I talk a bit about the ethical aspects that secondary use of data, when we speak about intellectual property right, is something very important and yet unclear. Can we use the data from, for example, children who report us their health condition? To what extent we are allowed to use it? We have GDPR, so it's a very clear and good guideline to the extent that we can understand what can be used, what cannot be used, but still we should, I mean, make it very clear. So if you please show the next slide. We have two main things in this project, in Synergy project. One is a very clear data management plan. And that is something that we continuously updating, saying that what kind of data we are collecting, it regardless of, I mean, it can be interview, it can be, for example, questionnaire, it can be data from sensors about air pollution. It's a lot of different types of data. And we are making it very clear which one is open, which one is semi-protected, and which one is completely protected. And this data management plan, this is something that we should update it very regularly so we know that whatever we collecting from partners and users should be protected or not. The other way that we have tried to share our knowledge and expertise in the project is to form an ideal cluster. It's a collaboration between different EU-funded projects that they share knowledge and solutions. Of course, I mean, for example, in this ideal cluster that we are sharing what we are producing in Synergy project, we are not sharing the technical algorithm or big data analytics approach that we have used to analyze the data from the sensors in a school environment. So the algorithm remained protected, and the data, I mean, those who are open data can be shared with them. But I mean, the general knowledge and research data, it's always shared with them. So that is also, I mean, if you look at synergy, I mean, as I said, the project is still in, I mean, we are in half time of the project, but there are some open resources and accessible data that you can just take a look in that project. There is another project, if you can please show the last one. This is one very small project, and it's from 2017 again. And the reason I showed this project, maybe this is not really the case similar to the other two cases that I showed, but in U4 IoT project, it was a small coordination and support action project. The intention was to support 5 big, large-scale European pilot projects in which they were working and developing IoT technologies in different IoT application domain like healthcare, smart cities, smart agriculture, and also uh, elderly care in Europe, and also automatic cars, so self-driving cars. And in this project, also, we had the case of secondary use of data. What we did in this project, unfortunately, the website of this project is not up and running now. That's a common problem with many European projects, because sometimes we produce a lot of resources, but we cannot keep it for many, many years after the project. But what was the main discussion here in this project? To give the main pilots, the big pilots, give them this understanding about the data ownership, the secondary use of data, because they collected data from citizens in different contexts, and how the data can be used, how and what should be protected. And that's the same. We cannot generalize. I have some advice or some recommendations that can be used, but as I said, there is not a single solution for that. If you show, please, the next slide. As I said, in this project, it was mainly ethical concerns, and also the activities that we tried to educate them. How should we keep the information or data from your users confidential as much as possible, and what should be shared and what should be open? So here in this project, we also tried to promote user engagement. That is something that will highlight the possibility of using technologies by end users. And of course, I mean, as most of European projects, the public deliverables and toolkits and handbooks are publicly available, but we never shared the main solutions that those IoT technology developers they were working with them. However, I mean, they gave us access to some of the technology-driven innovations and, as I said, the algorithms, but these are some things that we could not really share, and that should be protected. So this was my last example of the project, and the intention was to show you that in each project, IP management can be different. It really depends on the context of the project and the way that we are going to manage it. If you show, please, next slide. Is it? Yes. Next one, please. So what we learn generally from the projects and from the experience is that it's always unclear the ownership of data, knowledge, and expertise and ideas in a collaborative setting, in multi-stakeholder setting like Living Lab. So that is always a challenge, and there is not a clear way to say that what should be open and what should be protected. So there are some solutions. For example, we cannot say that if it's open, everyone should have access to that. And if it is protected, no one should have access to that. That I show you in the next slide. But I mean, generally, what we are recommending is that you should think about that. Not we cannot treat the same data set exactly with, I mean, in the same way that different partners, they will have access to that. So the other point is that in, for example, in one of our projects, as I said, we were developing university courses with some South African universities and Russian universities. So there also we had some discussions because the regulations, IP rules and regulations in different countries and different continents are completely different. So you should be always aware of IP rules and regulations in the context, in the, for example, the country that you are partnering with them. So, for example, here we adhere to GDPR quite a lot and we are familiar with that. But maybe it's not applicable if we are working with other countries from other places. So we should be aware of different regional IP laws. And also another important aspect, as I talked about being proactive and reactive, is that IP agreements can be evolved over time. That means if we draft something, if we agree something, we cannot say that it's always this and we cannot change it. Of course, we have to be proactive, but we should be open to change, I mean, over time and update it depending on the situation that will happen. If you show next slide, please. So one solution for that, or one suggestion, is to implement tiered access models. And that is something that tells you different actors in collaborative setting, they might have different access to the data or knowledge or whatever that should be open or protected. For example, maybe public access I mean, public can access to something, but some of the, for example, tools and technologies or algorithms, they must be protected. So we should define who can, for example, have access, who can use and modify co-created IP agreements and IP rules and standards that we have developed. So also, the other point is that when we collect data from our citizens, we should always, I mean, be in line with GDPR and data ethics. This is very important. These two, I mean, IP, IPR, and ethics specifically, when individuals are in the loop, is very, very important. And also the level of openness, as I said, this is something that we should decide. We should discuss about it, but we should always think about that in some solutions, we cannot be completely open. So define different levels of accessibility to the solutions that we are developing. That is something important in your project, that it doesn't need to have, for example, one level of accessibility for everyone. Next slide, please. So also conflict management, that is something really important. And as I said, we always try to draft IP agreements and IP rights before starting the project. Of course, if we are submitting project proposals, as I said, for example, in Synergy project, so we knew that we want to really protect and file patents about something. And before starting the project, it's good to know, it's good to have an overview what we are going to share and what we should not share. Development of a clear data management plan, that's what, for example, we are doing currently also in Synergy project. So we should outline the protocols for data collection, storage, sharing, and protection, where we store the data, who owns the data, who will have access to the data, and so on. Ethics here is very important. And also we should sometimes define ownership based on contribution. That does not mean that whoever contributes more will have access to more data. No, but based on the type of contribution, for example, lead researchers may have access to the innovations and or also some, for example, more protected knowledge, but maybe citizens, it's not really there are cases that we should not make some data or knowledge completely open for every citizen, because there is a high possibility of misuse of data, or as I said, secondary use of data. And set rules for joint IP ownership. That is also very important, because in any project, however, for example, we are expected to be as open as possible. Still, there might be something that will be commercialized or should be exploitable results and should be, for example, protected for the partner. So we should set rules for that as well. Uh, if you go, please, to the next slide, I think it's just about some ethical considerations. Next, please. When we discuss about IP and IPR, it's very important to also consider responsible research and innovation. Now, for example, we work quite a lot with living labs, and we already have the concept of responsible living lab. That means living lab activities should follow responsible research and innovation guidelines and principles. And that responsible research and innovation means research and innovation always must be in line with societal needs, ethical values, and sustainable goals. These are important and, of course, will help us to understand the extent to which we can share data, and we should be open, we should be transparent, we should, for example, think about possible uh, ethical issues that we may create. For example, now we have the concept of digital divide. If we are, for example, developing innovations or technologies, those who have access to innovations, those who do not have, if we are creating, for example, this division, then we should rethink about IPR aspects, that are we really creating digital divide between two groups of people in the society? So unfair exploitation, as I said, and also some other ethical concerns about commercialization and transparent decision making. The decision making is, if it will be like participatory decision making, so it will be easier for us to decide what should be shared, what should be protected, what if we, for example, file patents or not. And please, next slide. I think it will be the last ethics slide about ethics. There are also some other discussions when we are, for example, collecting data from citizens. Sometimes it's really difficult for us to decide what should be shared, what should not be shared, because always citizens are in the risk of unintended participation. This is a big ethical concern. For example, in one of our projects, we were installing smart cameras at the airport terminals to measure, to see, for example, to identify which area is crowded in which time of the day, or so on. We were collecting data from from citizens, but they didn't know that. I mean, they knew that, but they could not really exclude themselves. That is called unintended participation. Then we want to think about, for example, intellectual property, or who owns the data, who can reuse the data, how the data can be reused. These are issues that might happen in this way because they cannot really exclude themselves from this kind of experimentation. And that's the same with sensitive users' data, for example, in the case of healthcare, as I said. So GDPR will help us a lot, but still we should consider the data that we are using when we want to, for example, define the IP rules and standards and protocols. To what extent we have control over the data we have. For example, do we have the risk of data leakage? Do we have, for example, secondary use of data? Who owns the data? Where to store the data? And these are something that will directly affect our, for example, protocol for intellectual property when we are developing that before or during the project. So that was very quick overview of the things that we can consider, the solutions that we can think about it in our projects, and what we can, for example, do. But of course, as I said, there is not one solution for every situation, but yeah, that was just an overview of what we are doing.
Thank you so much to both of you for the very insightful presentations, really. I saw that while you were speaking, we received a few questions in the chat box. Both are from Catrian, so I would like to read them out loud for you for the trainers to reply. So The first question is, what is your advice when working with partners with much more experience and in-house expertise in tech transfer and IP, e.g., a smaller research partner versus a big university?
Yes, please, Julia.
Okay, maybe I can start on this one. As you were saying before, one of the key principle also on the ethical approach to IP is the fairness that Razul was just presenting before. So it's important to be fair and always in every we saw at the beginning the collaborative environment, the trust is essential, but we also need to be smart. So in particular, consider here you have the example of a smaller research partner, and the big university could be the same with larger companies or other environments. Larger organizations usually are supported by in-house legal or technology transfer departments or units or offices that can help and usually have a very well-structured understanding of the procedures, what can be accepted, how to proceed, and so on. These can be scary for smaller partners, but not necessary. So my personal advice is to when you are a smaller organization, not having in-house support on such a legal matter is to still ask and dedicate some of your budget resources for dedicated support. For making sure that you have the necessary understanding for identifying your general strategy as a small organization. So what you can accept, what you cannot accept. So having first a strategy as your individual organization that can then facilitate the collaboration with other organizations, but also having available some external legal consultancy that can help you for supporting heads-on and specific situations. So this is my general principle. And when this collaboration is happening in the scope of a consortium of a structured project, could be Horizon or other, is not to underestimate the consortium agreement. This is something that usually happens. This is something that will define the future steps. So don't underestimate the negotiations, the consortium agreement. The small organization and the large organization has the same equal say on the rules and the procedures and the steps. When you are also acting in the context of a collaborative projects, it's always recommended to have a partner dedicated to IP management, which is external and more fair and imbalanced, and so not preferring one partner or the other to support in these matters as well. So this is my recommendations. I don't know if Razul, you have anything to add, or if you want to address the other question, which is more for you.
Thank you. No, I think that was very complete. And so perhaps I go to the second question. Yeah, it's about the the first two projects that I was explaining. If the companies launch a marketing campaign for the developed sensors, no, they have not done so, and I can tell you exactly what happened. The first project, which was finished 2023, we started 2017, and yeah, it was 5.5 years project. So what happened in that project? Of course, for example, the smart dashboard that our partner in Italy, they were developing, it was open to some extent to the partners and cities who subscribed during the project lifetime to use it, but I mean they did not really implement the whole solution in the cities. But since the partner, I mean, of course, they were funded by European Commission, they made it open upon request of the companies or, I mean, municipalities in Europe if they wanted to, for example, learn more, or if they want to really replicate that one. But the other, I mean, after the project ended, I know that they have more developed that solution, and that is something that it was clearly from the beginning that they have the right to, I mean, they own the code and the source, and also they developed it for their own purpose. But of course, I mean, those, as you asked, those individuals or municipalities or companies, no, they got information based on, I mean, dissemination activities that we were doing during the project. And it will be the same with Synergy as well, because now we are, for example, the game that we developed, of course, it's already openly accessible. I think it's in a very, very final stages. I mean, it's in Play Store, and also, I mean, they are working on finalizing. But the main technologies, as I said, the smart boxes that they are installing at a school, no, they have not made any marketing campaign, but still, as I said, it will file as a patent. They have the right also to extend and use it for other purposes. But yeah, I mean, public, they will get information through project dissemination activities.
Thank you so much, Razul and Julia, for addressing both questions. In the meantime, we've also received other comments slash questions. For example, the first comment is by Fotis, saying important issues related to IPR are also the cost, e.g., establishing and maintaining or renewing patent rights, and the costs and options related to legal actions protecting IPR from infringement. So this was, Julia, I don't know if you want to.
Yes, indeed, the cost for IPRs is something that it's important to plan since the proposal phase. I would not, I'm still an optimistic person that tries to not plan budget for infringement and legal actions based on the good faith in a collaborative environment. So in general, in projects, I don't plan for costs for legal actions. But indeed, it is important since the proposal phase to identify the type of IP. Remember, we saw it before that in the proposal phase, we can define which IP we're going to define and the potential IP pathway. And for that, it's important to, if you identify some IP that could be protected during the project implementation, to plan in your project budget the necessary costs to cover that are fully eligible as part of the exploitation process, at least in Horizon projects. Then when, as we saw before, on the different types of IPR that you can consider, of course, the cost and the budget plays an important role, as we were seeing before, not only for the type of protection, but also on the scope and the geographical scope, as we were seeing before. So thank you, Fotis, for raising this point. I see, maybe I can go ahead, Ariana. I see another question from Ali Reza. Sorry for the pronunciation. So it's how do you set rules for joint IP ownership if collaborating partners have predefined IP rules, claiming their own ownership on the project? It's the general here. I can bring my general example from Horizon. Maybe Razul can then complement on more concrete examples, but is that the ownership is not of who claims it, but on who contributes to develop the solution and the IP. So not on the entire project, not on the entire solutions, but who delivers it. There is specific terminology. And for joint, this is something that you need to consider from the very beginning of your project, identifying where really joint ownership can happen. In this case, is that the clear definition again in the template of the consortium agreement is that ownership is shared among the partners that contribute, partners or beneficiaries that contribute to the development of the specific result, intellectual property, and that it's their own responsibility for defining how to manage such joint ownership if there are some specific conditions like shares of income or percentages of ownership. If you see that joint ownership may happen in your project or in your activity, red flag, be prepared on negotiating. There is also the general application, general rules which allows to both joint owners, both or more, sorry, to use the result as long as the necessary information is shared with the other owners and no exclusive license is granted. So these are the conditions, but of course the joint owners can define more detailed strategies. And there is no predefined IP rules. So of course, everyone needs to have its own strategy, but the rules are fair and recognize the ownership to those that contribute to the development. I don't know if Razul wants to add. Otherwise, there's a really interesting question that maybe you want to address.
Yeah, I can actually add something very small to the point that you explained about the IP rules, because we had the case, of course, that's the reason we try to highlight co-creation of IP agreement and standards with every stakeholder. We were developing, I mean, we were going to develop a decision support system for railway system in Sweden. And we had even, I mean, we had a discussion with our partner. I mean, even though they were not a private company, it was a public authority in Sweden. But we didn't reach any agreement because they thought, I mean, what we develop in the project can be really, I mean, under their own control and their own, for example, protection. And that was something that when we discussed with our Swedish financier, they simply didn't agree with this solution. So that means there are, of course, cases that from the beginning, I mean, if they claim something differently, we may not even start the project at all. So, I mean, that happens, co-creation of these standards and agreements. That is very important. That's why we think from the early, we should really do that. Or do we? Okay.
Thank you. Then we have a question by Paul, saying, first of all, this was a very interesting presentation about IPR and useful for those new to the topic. So thank you. So I feel that so far the aspect of citizen contribution has been vague. Much of co-creation originates from personal experience. So where there's a solution based upon that individual knowledge and the solution evolves into exploitable asset, where does the IP rest?
So do you want me, Julia? To? Yeah, of
If you have
course.
some concrete examples, that would be great.
I mean, not really an example that I can share, but the point is that I mean, always when we have citizens in the loop, I mean, we have a lot of more restrictions. That is very obvious I mean, in the situation that we are facing. But I should reread it if that is what he meant. The solution was into. Okay, yeah, if it's about the exploitation, that is something that, I mean, for example, in one of our project, we had I mean, the community representative. That was something that they could, because usually it's really difficult to uh, develop these IP agreements and protocols and standards with I mean, with individual citizens. So we should find representatives and I mean, have agreement with them because they usually follow, I mean, they are aware of the rights and the level that we can share or the level that it should not be shared. But yes, that is something that we always consider the citizen, I mean, engagement in the process, but sometimes we have to really bring their representatives in the networking. But yeah, I don't know if that was really the answer for me. What I understood is that, yeah, yeah, that was.
Yes, Paul. Maybe I can step in, sorry. Oh no, maybe Paul, you go first and then I can step in as well.
Thank you. I appreciate it's a really challenging question, but I think it's one that's quite important to a lot of the work that we are dealing with at the moment. I think perhaps the question is more about when we have people who share their ideas and their ideas turn into something which is exploitable, how do we make sure we address them as the originators? Because if we were to go and say, produce the next vehicle that solves a load of problems that they brought up, they could rightly say, that was my idea. And we would need some way of being able to address it and say, we would compensate in a certain way, or we would have a very specific definition of how that might work within a research project. But I think at the moment, we're all kind of guessing that, as you say, Julia, that it's kind of done it in the best intentions to move knowledge forward. But actually, somebody could come back and say, my knowledge has become an exploitable asset, and therefore I want to benefit from it. So I think we need some kind of statement that covers us for that.
Yes, well, it's usually hard for it to be one citizen that can claim, because if you really do a collaborative exercise, or you don't involve one citizen that can directly claim the result, but you involve more of them. I believe we, as you know, Enol is not a hands-on experience, so we are on the citizen engagement. But what I could feel to recommend is to have specific explanations on what the result is going to be used for from the very beginning. And this is really going back to what I was saying about the building trust and making it a safe environment. So the result is for the sake of the community. So it's supporting the community, the specific goal you're working on. Okay, maybe one organization that has the lead of the activities, that is the one organizing the co-creation exercise, is the one that is going to maintain the major management of the IP and the solutions, but everyone has a stake in it and can benefit from it. Maybe not a commercial from the commercial point of view, but this is going back to the result, and the activities we're doing is for the greater goods for the entire community. This is a bit what I can recommend. And also is really to make sure that you have a statement from the very beginning, like everything we do for GDPR compliance. So every time we need to explain what we are using the data for, who has access to the data, and so on. This is the same principle. So to recommend an informed consent also on what you are going to use the contributions for. I believe this is the key element for building the trust and facilitating the collaborative environment. I'm not sure if Rasul wants to add on that.
Can I add something to that for Paul's question?
Yes, sure.
Paul, if a citizen or other actor decides that they may have some interest in exploiting those exploitable assets that you mentioned, even later on, what they can do is negotiate a joint ownership agreement with the other actors that are also interested in that. So this is a negotiation process that can happen either early or later on. So that's the mechanism. As soon as you establish these rights in the joint ownership agreement, then the IPR are more specific.
Yes, but this is, of course, making sense in the more collaborative environment between organizations, and not easy to identify joint ownership when you involve 300 citizens in a co-creation exercise. So thank you for this. I totally agree with you. My recommendation is really to be clear from the very first start on what will happen and what is the benefit of contributing, which may not necessarily mean having a stake in the exploitation, commercial exploitation. I don't know if Rasul wants to complement on that further, or if we have other questions, in easier ones maybe in the meantime. Thank you, Paul. I'm joking. It's a really good, challenging question. I don't know if anyone else here wants to comment on that as well, or.
I might just add that actually I think it's a really important statement at the very beginning, and having that kind of clarity to say, should this evolve into something which is exploitable, this is how we would handle it. But we're kind of discussing this in kind of infinite detail. If there was just a statement that says co-creation works in this way, it's collective, we're avoiding barriers that cause problems in the future, and as you say, maybe the greater good is sort of the right kind of description, but it's that kind of route to a greater solution. Then the question of somebody investing in it to exploit it is a different matter, but it just needs to be a statement at the very, very beginning of co-creation, I think, which would be really useful. But thank you for trying to tackle it so far.
You're welcome.
Thank you. I see we have another question in the chat from Milan. First of all, who thanks you for the nice presentation and then asks, do you have some tech transfer success stories to share? License, startups?
Not specific license or startups. I'm representing Enol, and we are not-for-profit organizations, and so we're not yet in, and also for the type of activities we do, this is not the core yet. But maybe I can bring one of the examples on the different valorization. So we focus more on valorization of our results. There is a dedicated unit, for example, subunit in the projects unit that I lead in Enol, that is working on valorizing and reusing further the results. One of the examples I can bring is the Living Lab Canvas. This Living Lab Canvas, for example, has been used for developed in one project to support the setup of living labs and really facilitating the living lab understanding and reasoning which core actors, which activities they needed to bring on board, and so on and so forth. And this canvas has been further developed and improved over time with through different projects. So every time Enol was bringing it as a background in new research projects, and through the co-creation with the different partners, stakeholders, and actors working in the project, we continued to improve these results further. So this is an example. It's not a direct tech transfer, but it's still an example of how the same result has evolved through 6 different projects over time, always improving, always building on previous research, but always improving it. Another example comes from our other coordinated project, Vitalize. For example, in that case, we have been working on the harmonized evaluation framework for living labs. There was an harmonization boards that identified criteria for supporting the evaluation of how living labs were complying to the principles of living labs, the living labs methodologies, implementation of tools, and so on. And this came from, it's an IP, a collaborative IP that came from the collaborative work of all the Vitalize partners and external contributors board. And this is at the basis now of the Enol certification process. So all the new Enol Living Lab that Enol certifies twice a year are undergoing an assessment process that is following the questions and criteria identified, for example, through Vitalize. So this is not a formal not a formal tech transfer, but it's more of valorization. I don't know if Rasul has other examples to bring on the table that are more linked beyond those that you already presented before, of course.
No, I think more or less that's what, I explained. I mean, we are very much on non-technical side, honestly. So, and it's like you, I guess. So, No, I mean, other than what I explained with those, I mean, those who protect their, I mean, algorithm or, I mean, technology tools or things. No, not really.
Yeah. Yeah, thank you. Thank you very much for sharing this. I was asking because lately, majority of the people that talk about technology transfer talk from the theoretical side, and I'm always looking for not for theory, but for the real success. So I was looking for maybe if you or some other participants have some success stories to share. So, but thank you for answering. I think that we need more real examples and then less theory, because let's say the theory can be taught by anyone, and a real example from someone who went through it and who really have the sweat on the shoulders of the hard work, that's the true value that I usually get from lectures. Thank you.
Milan, I have practical experience. If you want to talk, we can talk offline if you wish. We have 18 patents all over the world, so we can talk
Okay,
details if
Fotis,
you wish.
I will contact you. Fotis Liotopoulos. Okay. Thank you.
Thank you. I believe we can facilitate the connection after the meeting. So thank you for this.
Thank you so much. I see there's another comment from Foris, but before that, I think Rasul, you might need to go.
Yes, I think, yeah, I have to, unfortunately. But thank you so much for everyone who participated in this session and your very nice organization, and hope to see you all very soon. Thank you.
Thank you very much,
Thank you so
Rasul.
much.
Thank you.
Thank
Thank
you.
you.
Bye-bye.
Okay, and since I see that we only have 5 minutes left and we are missing just one bit for this session, I would like to move to the final Mentimeter that I will show you the details to enter in. So this is the code that you can use. It is 71811071. If Gabriela, you could please also share the
Yes.
code in the chat. Thank you. As before, you also have the QR code, and hopefully you're all using the code in the chat, because I will stop sharing and go to Mentimeter now. Okay, so as promised before, I don't know if you managed to enter. Okay, yes. As promised before, now we are wrapping up this session. Thank you again very much to Julia and Rasul for the very insightful and interesting presentations. We hope you now have a little bit more knowledge on the topics that we've encountered today. The question was, how much confident do you feel now after the training on intellectual property in general and intellectual property in collaborative environments? And if I don't remember wrong, the average before was 3. So in intellectual property, we now added the collaborative environment part, but I see that we are now at 3.4. So it seems like the training was actually helpful for you to get more acquainted with the topic, which we're very glad about. Okay, let's see if other replies come in. Yes, anyways, it seems quite stable. But this is a good result, because this is a very tricky topic, and also getting some more, I don't know, some little point source, having a wide knowledge on it. It's something that we have to take into consideration. Then the next and last question, if I'm not mistaken, is what was the most valuable insight or lesson that you learned during this training? Again, like before, okay. Yeah, I was about to say, write the things that come to your mind and that really stayed in your brain. Okay, so I see start early. I guess whoever wrote this refers to the whole process. To start or early thinking about IP and IPR. The tiered access models were interesting for someone. That we need to develop clarity in the definition of IP in co-creation, the intellectual property rights. And also you found interesting or something that stick to your mind was to have open conversations and keeping everything well documented, including the contribution of every party. This is indeed very important. Exactly. Another comment similar to the first one, start the IP definition as early and complete as possible. Yes, it is very important indeed, and we're happy that this is something that you will bring home from this training. Okay, let's see if a few more replies come in. Otherwise, it's 1 p.m., so we are perfectly in time to close this training. Okay, that was the last.
No more questions.
No, exactly, no more questions. And that was the last part. So I would like to give the floor to Gabriela for final considerations and closing.
Thank you very much, Rihanna, and thank you all of you for joining this training. We really hope it was useful for you and you will bring home very insightful lessons learned that can be applied in your researches, in your projects, so supporting your daily job, let's say. I would like to remind that you're going to find the presentation and the recording of the session soon on our hub and on our website, and be ready to reply to our feedback form that you're going to receive this afternoon. So to provide a more structured feedback about the session, and possibly also inputs that might be useful to co-create the next sessions foreseen in the capacity building program that GILL will perform until the end of the year. So thanks a lot. Thank you very much again, Julia, for being one of our precious trainers. And I wish you all a very nice afternoon. Thank you. Bye-bye.